The first matter in the morning come before the court is State of Ohio versus Stephen Thompson. As you know, each party will have 15 minutes to present oral argument. The appellant will proceed first and may reserve up to 5 minutes for rebuttal. If you wish to reserve any time, you'll let me know. Let's see if I'm not speaking to you. You would be the appellant, right?
Correct.
Okay. If you'll let me know, I'll be keeping time. We've read the briefs and we're ready to proceed with the call.
Thank you. Good morning. May it please the court, my name is Stephen Bradley on behalf of defendant appellant Stephen Thompson, and I would respectfully request 4 minutes of my time to use in rebuttal. Your Honors, it is important to appreciate that the key events in this case took place in less than 2 seconds, which was the length of time it took Stephen Thompson to drive his vehicle down an incline of a driveway. And the jury in this case was called upon to decide whether Mr. Thompson drove his vehicle down that driveway knowing that there was a state trooper in his path, as the prosecution maintained, or whether Mr. Thompson was simply trying to leave the scene and was unaware of the presence of the trooper, as the defense maintained. And to support our position, we retained the services of 3 expert witnesses, most notably Henry or Hank Lippian. And Mr. Lippian is a long-time, well-respected former state trooper himself, who has testified on these issues for literally decades. And his testimony has been offered by both the defense and the prosecution in cases throughout the state of Ohio. And Mr. Lippian actually was prepared to offer testimony on any number of issues, but primarily on the issue of human factor analysis, and more specifically, whether Mr. Thompson was physically capable of perceiving, detecting, perceiving, and reacting to the presence of the trooper. And
that is a subject that has been widely criticized by jurists, I was going to say around the state, but even around the country, as being junk science. I'm not sure that the issue of a Daubert hearing or a Daubert issue was raised in connection with the exclusion of this testimony.
It was not. The issues that led to the exclusion ultimately centered around the potential for jury confusion because of the one of the elements that was taken into consideration was with intoxication. But it's not junk science. And in fact, it is Mr. Lippian did, I think, offer some testimony that these very topics he routinely teaches as part of the curriculum to the state troopers that are, new troopers or part of their continuing education. And these issues are clearly beyond common knowledge of your average person. And that's evidenced through his report, where he talks about a convergence of a number of factors in this case that would have made it physically impossible for Stephen Thompson to have detected and reacted to the presence of the trooper who was standing at the end of the driveway. And the issue and those conclusions were reached without regard to the fact that there was intoxication. Amongst those were the fact that it was nighttime, that there was, by the time he turned his vehicle and was heading down the driveway, there was this wall of light, the headlights from the trooper's car, the color of the trooper's uniform did not provide any contrast, and other factors along those lines that make it a very scientific conclusion that would have taken at least 2.5 seconds for an unimpaired driver to have been able to detect, perceive, and react in the presence of that trooper. And what happened at the trial court level is that the prosecutor was able to convince the trial court judge that the alcohol issue was what was potentially confusing to the jurors. 2 points on that. Number one, Mr. Lippian reached his conclusion without regard to the consideration of alcohol and namely the impossibility to detect the presence of a trooper. And number two, he further found that the fact that he was intoxicated just contributed or further supported that conclusion that it would have been physically impossible for him to perceive him. And that is right in the revised code that, generally speaking, you cannot consider the issue of intoxication to vitiate any culpable mental state. But that same statute goes on in the same paragraph to say, but it is relevant to the issue of physical impossibility. And that's what we're talking about here. It was physically impossible for Mr. Thompson to perceive and detect the presence of this trooper and then react to his presence. And
so your witness was not willing to say that it was physically impossible, just that it was very difficult.
no, I think he would have said it would have
Is it possible to see him in that, or impossible to see him and react?
in the time it took to drive down the driveway, which was somewhere, well, we can debate the minutiae of it, but it was certainly less than 2 seconds. That is correct. And it's important when you are considering that conclusion to understand all of the various factors that contribute to that conclusion, including the fact that Mr. Thompson, the testimony was Mr. Thompson's attention was focused away from the direction of Trooper McClintock, that there was a wall of light where Trooper McClintock was standing behind that wall of light, that it was otherwise dark, that these were unfamiliar surroundings, that Trooper McClintock's gray uniform did not provide any contrast, and that the distance, taking into consideration the distance and the approximated speed, that he would have traveled that driveway in less than 2 seconds, and that under those circumstances, not that it would have been difficult, physically impossible. And that, the fact that we could not present any expert testimony on this issue and several other issues, i.e. the wall of light and the significance of that, was really exploited by the prosecutor throughout the trial, particularly in closing argument. And that's really key here, because the prosecutor stood in front of this jury and argued that, hey, we drive on the road on a daily basis. We're forced to react in a split second all the time. You know, the ball rolls out in front of the car, whatever it might be. And that in 1.5 seconds, which was the approximate time for him to travel down the driveway, would have been plenty of time for Mr. Thompson to have seen him, appealing to jurors' common sense, I guess, knowledge and understanding of this. And went on to say, again, further exploiting the fact that we could not present this expert testimony, that this whole discussion of the wall of light was just a defense theory that was concocted by defense lawyers without any evidentiary support. And in fact, that too is another one of the subject matters of training that Mr. Lippian offers to the state troopers, that there is in fact legitimate reason why troopers are trained to stand behind the headlights of their car, because it does create this wall of light such that it inhibits somebody's ability to proceed.
But the impression I'm getting from your brief was that he wasn't on the driveway, he was driving the grass alongside the driveway, and that the troopers' cars were in the driveway. In fact, one was hanging out on the road. So this guy's coming down the grass and down toward the street. Is that correct?
Not entirely. He pulls in the driveway, has an encounter with the first officer.
Locked in now.
Well, not really locked in, because the trooper was behind him, and he essentially drove up around a tree and now coming back down, and was in fact at some point in the grass area, but then corrected and got onto the driveway and then drove down the driveway, and at some point there was a significant grade here, and at some point, one of the front wheels was on the grass as he's exiting the driveway. So I guess to answer your question, it's a little bit of both. But for the relevant time that we're really focusing on, the 1.5 or 2 seconds it took for him to drive down the driveway in the direction of the trooper, he was largely on the driveway.
And you are at your 4-minute mark if you wish to reserve the time, or you can continue on.
No, I wish to reserve my time. Thank you very much.
Good morning. May it please the Court, Nathan Shaker on behalf of the appellee, the state of Ohio. Getting to the Court's recent question about how this incident occurred in the topography, that's important when looking at the appellant's sufficiency of the weight argument and dealing with what the jury had in front of them in looking at this 1.5 seconds to 2 seconds and perceiving and reacting to Trooper McClintock. That's the reason that we asked for a jury review in this case, because it's significant. I would ask the Court to take a look at the exhibits and the placement of the obstacles that Stephen Thompson had to avoid to get where he was in terms of getting around the tree, driving through the front yard, proceeding down kind of on the edge of the driveway in the grass, which is pretty much the testimony is that he was kind of, I guess, on the shoulder, so to speak, of the driveway as he headed down in this area that funneled down towards the roadway with a steep embankment to the side, a telephone pole, a small exit area, and the driveway where there was a police cruiser and then the trooper's vehicle. He had this narrow area between a telephone pole and an embankment and the trooper's car to navigate his SUV. And that's where Trooper McClintock was standing. Trooper McClintock, his testimony was that he would have to shuffle in this small area because the embankment was to his left as he faced the house and the vehicle was coming towards him. Mr. Thompson was able to successfully navigate around the tree, up in the yard, and down the hill, and go into this funnel where he was able to miss a telephone pole, he was able to miss an embankment, he was able to miss a state trooper's car, and the state trooper was in front of him at that point in time. That's what the jury was faced with. If you are in this funnel view, you've made it that far, would you not see that person there, and what's your reaction? You should brake. He never broke. The testimony was that the engine was revving as he proceeded down. And
that
that's...
doesn't really address the issue of the light, the impact of it being a dark night. And as I understand it, the spotlight on the first cruiser was aiming toward the car that the defendant was in.
That was, so the Sergeant Connell, Worcester Police Department, pulled in behind Stephen Thompson's car when it was faced, SUV, when it was faced towards the house. He directed his spotlight at his driver's side mirror. Stephen Thompson then drove a distance away around a tree in the yard, so that spotlight wasn't at issue. I believe what the defense...
I don't know as he was coming back around to exit the driveway.
He would have been past Sergeant Connell's car. If there was any headlights, it would have been the trooper's vehicle, which were to the side of the trooper. So the trooper was, I believe directionally, the driveway runs north and south. The road that exits runs east and west. When he headed up the driveway, he was headed north. When he headed down the driveway, he was headed south. The trooper's vehicle would have been to the west, and the trooper was in between his vehicle, or the exit to the driveway, and the embankment. And that's where Mr. Thompson had to navigate his vehicle. At some point in time, he certainly would have seen Trooper McClintock, and Trooper McClintock's testimony about the objects he had on that would have made him visible in those conditions. But it's also if you look at Mr. Thompson, the entire time, the way he was trying to elude Sergeant Connell in terms of turning off his lights and going up and down the dips on the road, he continued to try to flee after he ran. If this was just an accident, why wouldn't he stop? He continued to try to run. He tried to run on foot. He eventually ended up getting the SUV stuck on a bank. All those things go to the sufficiency of the evidence. Regarding the trial court abusing its discretion and excluding the defense experts' opinions, it's important to look at the ultimate conclusion of Henry Lippian, to cut out the underlying facts of that conclusion and use those in the absence of that conclusion, as the defense is asking currently, would have been all the more confusing. Mr. Lippian, on page 83 of the transcript, said his opinion was talking about culpable mental state. That was the problem that the court was dealing with, was culpable mental state. And just generally, when you hear Mr. Lippian's testimony through the 70s and 80 pages of the transcript, he doesn't seem exactly sure what he's opining on, but he does say he's opining on culpable mental state. When you look at that with the limited probative value, because I believe there's real problems with Choya Han's testimony in his report, he has no qualifications to testify regarding ballistics, and importantly, his measurements and his placement of the troopers was based upon pictures. When he initially wrote the report, his measurements and his placement was based upon pictures. That limits the probative value of both his statement, his opinion, and also of Mr. Lippian, who relied heavily on Choya Han in placing the where to place the trooper. Given that, the probative value is substantially outweighed by how confusing these reports were, how they would have confused the issues for the jury, and the court can err there. Unless the court has any further questions, the state will rest on the merits of its brief. I ask that the court overrule assignments of error 1 through 6. I do believe that the case has to be remanded for resentencing, consistent with 2914C.
Thank you. Any questions? You have 4 minutes.
Just responding to some of the remarks by the prosecutor. First of all, as it relates to Mr. Lippian's reliance on Choya Han's unreliable measurements, if you will, that's simply not correct for any number of reasons. First of all, if you look at Mr. Lippian's 13-page report that was proffered here, he makes reference in one small paragraph as to some of the findings of Trooper McClintock that are really not dispositive or relevant to the key issue in the trial, namely, did he perceive and react to the trooper as he was standing down the driveway or not. So there was really no dispute as to the general location of Trooper McClintock in that 1.5 seconds as he was driving down the driveway. Second, the notion that somehow he continued to flee after he exited the driveway as somehow relevant to the issue of whether he perceived the trooper is, I don't even totally understand that. The fact of the matter is that as he drove his vehicle past the trooper, there were several shots fired into his car. He crashed his car after he got onto the driveway, or out of the driveway, and fled on foot. Again, really not relevant to the issue of whether he saw the trooper or not. And the prosecutor makes the comment that at some point he would have seen the trooper. That's the point. That is the issue in the whole trial. Did he, in that 1.5 seconds, perceive that trooper standing behind those headlights? All the other variables that were in play, it's not as, you can't really isolate it on one simple, narrow issue, namely that he was standing behind the wall of light, the headlights. It's that plus the various other factors in play, the contrast, etc. So it is, the prosecutor says at some point, well, at what point? It was 1.5 seconds. And it is seemingly something that would be common knowledge, how long, whether he could actually perceive it or not. But it's really not. And so says a number of experts, including Hank Libyan, who teaches at the State Highway Patrol. He's testified on these issues for decades. And he's never, to the court's question, had his testimony denied, if you will, on some dogma challenge. And it was particularly damaging in this case that we do not have the ability to present this expert testimony. And then we're exploited by the prosecutor in closing arguments when they're throwing it in our face that this wall of light theory is just concocted by us without any expert support, knowing that our experts were, forced to the sidelines. And the prosecutor's remark that, hey, we drive every day, we make these split-second decisions, appealing that this is all common knowledge. But it's not. It's in fact the fact of the significance of scientific evidence to support people's human reaction time, taking all these considerations. So it was the key issues in this case, largely, did he perceive the trooper in that 1.5 seconds? Would the jury have benefited from hearing this expert testimony and hearing that, hey, there really is some scientific validity to this wall of light, and there really is something to be said about somebody's physical reaction time?
When you're talking about wall of light, I'm picturing both of those cars side by side with headlights flashing right in Mr. Thompson's face.
Right.
That's how I'm seeing it. These cars are actually one behind each other on the driveway. He's sitting down the side of the driveway. So I'm having trouble with it being a wall of light in front of his face or lights, consecutive lights,
Well,
cars peripheral to him.
if you will, here's car number 1, here's car number 2, here's the headlights, here he comes down the road, or the driveway. Well, but the headlights are right there. And the point is, the trooper's standing behind his headlights as he's trained.
But Mr. Thompson has his lights on his car.
Sure. But the point is that when a trooper is trained, stand behind those headlights because it creates that wall of light, and it makes it difficult for the other person to clearly see beyond those headlights.
We're going to see, I presume that in the record there will be some demonstrative evidence of where the vehicles were.
Correct. Right, and if I just may touch on that ever
Well,
so
actually,
briefly.
you may not, because you have a lot of time.
Very good.
I
I will say, yes, there is that evidence in the record.
Thank you.
Thank you very much.
Thank you both for your presentations. The court will take that under advisement, will issue an opinion which will be sent to both parties, and you can check the Supreme Court
Thank you very much.